Good afternoon, everybody. Thank you for attending our lunch hour webinar today on harassment and discrimination in 2026. While there's no updated case law necessarily on harassment and discrimination, I feel like what I'm seeing on behalf of clients in harassment and discrimination is changing and evolving, and New Jersey's a pretty tough state to do business in. So I thought what it would be good to talk about today is what constitutes unlawful harassment and discrimination. How do you as an employer have the best defenses available? What are your necessary policies? And we're going to talk about training and how important that is. And then also, just because it is all the rage right now with AI, particularly social media use, right? How can we utilize and protect ourselves given all the technology that is changing every day? So what constitutes harassment and discrimination, right? So it seems like a pretty simple concept. And basically what we have is harassment and then discrimination being two separate things. Harassment is unwelcome conduct based upon a protected characteristic. And I'm going to get to a slide on that in a minute. But protected characteristics is your age, your gender, your sex, your nationality, religion, right? Any of those things that is severe or pervasive enough. And how do we know what severe or pervasive we'll talk about, to create a hostile, intimidating, or abusive work environment. Okay, so that's our quid pro quo or hostile work environment. Quid pro quo is when someone says, sleep with me or you don't get the job, right? Not as common. It's the hostile work environment claims we see much more often. So if it's unlawful harassment, how do we know? We talk about it both objectively and subjectively, right? So what would a reasonable person find as offensive? What's a reasonable person, a jury sitting in the box in Sussex County today versus someone in Morris County tomorrow? We don't know, right? So it's always, I always talk about red flags, right? Who's that reasonable person? It depends. But if it would be offensive to anybody, that's what we want to be careful of. And it has to be that the victim actually perceives it as offensive. And again, we don't know. We look at what would be reasonable, but we want to make sure we're careful as an employer for red flags. So unwelcome conduct can be both verbal or written, right? So it's comments when people say things that are inappropriate. It's jokes that are based upon protected characteristics. It's rumors, sexual innuendos, the water cooler talk we used to talk about. But because of those changes in social media, technology advancements, those comments, innuendos are now being done more on our nice little phones than at the water cooler. And that's what we need to be careful that you as an employer are monitoring it, not just, in the office when people are talking, but social media also to the extent that you can and are able to. When we look at the laws that are important for harassment and discrimination, it's the ones we typically talk about, right? We've got our federal laws, our Title VII, and the ADA, or Americans with Disabilities Act. We've also got the ADEA, which is the age discrimination. We used to say 40 and over. It's become blurred to some extent. And then New Jersey has a law against discrimination, and that's more expansive, more protective to employees than the federal law. So typically when we're evaluating claims, we're going to look at the law against discrimination because that's going to have the greater chances of liability and concern for you. You as an employer in New Jersey, though, must comply with both. But again, it's typically the LAD we're going to talk about. When we talk about protected categories under the LAD law against discrimination in New Jersey, it's almost everything, right? If you look at this list, and we're going to talk about how easy it is to make out a prima facie case of discrimination, everyone is a race, right? Everyone has an age, everyone has a sex, everyone, right, has some sort of family status. So all of these things are the protected categories that no one can be treated differently because of, right? So genetic information, if someone goes to a doctor and brings back a note that tells you that they have a medical history for cancer. Perceived disabilities, right? So not only that you see someone who maybe we think they have a certain condition. So all of these things, the most recently added ones to the LED were pregnancy and breastfeeding. And, that's one thing, if you haven't looked at your handbook in a while, you want to make sure you're including. Of course, everyone has that clause, anything else protected by law, but you want to make sure pregnancy and breastfeeding are the most recent categories. And these are the things you can't treat anyone differently because of under the New Jersey law against discrimination. When we talk about unlawful discrimination, first we talked about harassment. We'll get down into that further. Discrimination is when someone says, you know what, I was fired, and I don't think it's because I performed poorly for the past year and they're making a business decision. I think it was because of and then go back to this list, right? So you think, well, I can prove against that. And you always tell me employment's at will in New Jersey, which means you can be terminated for any reason or no reason, as long as it's not a discriminatory reason. So I'm just going to let this person go. And I think this really explains why it's difficult in New Jersey, right? So there is a United States, and this is across the country, but it's the United States McDonnell Douglas case from 1972 that says in order to make out a prima facie, or write your initial case for unlawful discrimination, the plaintiff first has to make out their prima facie elements. And we'll get to that in a second. Second, so if they can show that they've met the prima facie case, they've shown that, let's use race, right? This plaintiff says, I wasn't discriminated against because of my terrible performance. I was discriminated against because of my race, right? And they say they can prove it for whatever reasons. Then you as the employer have an opportunity to say, no, it wasn't for that. It was because of your poor performance. How do you show that? We always talk about document, 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 right? You want to be able to show that poor performance, because if not, we get to step 3, which plaintiff can come back and show that you, the employer, your reason is not true or pretextual. The real reason is discrimination. So you want to document everything that you have to support your number 2 legitimate non-discriminatory reason for action. So then we get back to 1 is, what's the prima facie case? What does a person actually have to do if they feel like they're discriminated against based upon one of these many things? What do they have to do? It's actually really simple. They have to be a member of a protected class, right? So if they're saying race discrimination, whatever race that is, if they're saying religious discrimination, gender discrimination, so they're going to make that prong, right? Number 2, performing jobs at a level that meets your employer's expectations. Seems simple enough. I put sort of there because in reality, what the case law tells us is if they're there and showing up, right? They could be the worst performer, but unless you've terminated them, the presumption is that they're meeting your job expectations, right? So that's also a tough one. And number 3, there's an adverse employment action. So the typical adverse employment action is a suspension or a termination. It could also be that you moved a person's desk, right? It could be that you change their lunchtime. It could be you change their work hours, that you refused a training for them to go to that you let someone else go to. So anything could be an adverse employment action. If it is a termination or some sort of change in roles, the 4th prong of a prima facie case is that the plaintiff, the employee, was replaced. All right. So if an employee comes to if an employee's fired, they're mad about it, and they go to an attorney, the attorney's going to look and say, okay, can we meet this prima facie case first, right? Then they're going to go back and say, if we do, these are the 3 things we need to go through to analyze if we're ever going to get your claim to a court. And what I'm telling you is this prima facie case is not too difficult in New Jersey, right? So to fight evil, you must know evil. You must understand what these things are, right? Because I know we always talk with at will, I can do what I want to my company, and I totally support that. But understand, in order for you to be able to best protect yourself, you've got to document the reasons you're ever disciplining an employee, right? Or making changes within the employment process so that you can go ahead and specifically and efficiently defend yourself from that action. So that is more of the discrimination one, right? When we talk about harassment, that's a tougher one to define. But I've done this before. If you've attended my seminars where I go through this definition, right, where it's unwelcome, verbal, visual, or physical conduct of a sexual, religious, age, whatever it is, nature, that protected category, severe or pervasive, affects your working conditions, or creates a hostile work environment. So what's unwelcome conduct? Again, we look at a reasonable person and we look for red flags, because if it's welcome, it's not unwelcome, right? Of course. However, what I see as welcoming, somebody else may not, right? So we have to remember it's both objectively and subjectively. What would a reasonable person find offensive, and what did that person actually find offensive? And that's where some history can come in. But I think the days of, she wore whatever, so she asked for it, are gone. So I don't know how much that matters as much as it used to. It's more what that reasonable person would find to be offensive. I know we talked about the comments, the jokes, the rumors, anything like that. Again, not just said verbally, but if they're written on social media posts. We talk about posters where people used to have calendars that were inappropriate, drawings. Now we have to talk about screensavers, emails, internet websites, right? If someone walks by and someone has something inappropriate on their screen, if they're showing someone even on break time, right? Like, are they violating our policy? I would say yes. Now, physical conduct, we talk about assault, touching. Either someone's not letting someone leave their office, somebody's hugging, looking somebody up and down. We talk about the wink, right? Gestures. There are so many gestures, and going back to verbal too, things, the 6-7 is okay, but there's other things those kids say that I have no idea what they mean. If you don't understand, let's be careful on what it is, right? And same thing with the facial expressions. So unwelcome conduct of an illegal nature, right? So where does this occur? It can be anywhere now. We used to always say we don't care what happens outside of this workplace. We now have to be careful, because what someone posts on their Instagram on a Sunday night is often brought into the workplace, right? So we need to make sure we're monitoring that. And when people are on business trips, when they're on meetings, when they are at the holiday party, we have to make sure none of that harassing or discriminatory conduct is occurring. How do we do that? Is we make sure we have policies and we're making sure we're enforcing them, right? And make sure it's clear that it's not just when you're in the four corners of our building, it's when you're out and about also representing the company. When something is severe or pervasive, it's typically a pattern, right? Where someone is repeatedly calling somebody out because of their gender or they're engaging in conduct, but it can be one incident, right? And it always is going to depend on the factual circumstances surrounding that case. But again, it's what a reasonable person would believe. So were the conditions of employment altered? And was it hostile or abusive? Again, it's what a reasonable person would think. So that's a gray area that you don't want to get to in front of a jury, right? You want to be able to show that it never reached that point because you had policies that prohibited the discrimination and harassment. If something affects your working conditions, it either interferes with their work performance, and it could be minuscule, right? Or it creates an intimidating or offensive work environment. And again, what's offensive to you might be different to me, and doesn't always have to be a supervisor, right? We have instances where someone who just works in a different department is cruel, right? Or they're the ones who make a sign on a locker, whatever it may be. It doesn't have to be a supervisor, it's anyone who affects the working conditions. And that also includes your UPS guy or the mail guy or the person who comes and fixes the copier and gets in and spends all day with these employees, right? You need to make sure they all are not harassing or discriminating against anyone based upon their protected characteristics. We look at the nature of the conduct, right? If someone's going to look at it, the court or an arbitration mediation is going to say, how frequent did this happen to be hostile, right? Like if someone makes one comment that maybe is offensive to somebody, is that going to be enough? But if it's a whole group, and if it's a supervisor, it's worse, of course, right? Because that person has authority over that person. Who joined in, right? Was it an individual or was it a group? So who can be a victim, of course, again, is anyone. And you don't need to have economic injury. You don't need to be terminated to be liable. There's cases where someone stays employed, sues the employer, and they still are found, the employer is found liable for discrimination or harassment. Oftentimes, then they become responsible for back pay, right? And any loss in promotions or anything like that. So you want to be careful and understand it applies to everybody. And again, it can be your supervisor, a coworker, it could be a vendor, any gender, any age. It can be anyone who commits that harassment. Now, harassment is not asking employees to do their jobs according to their job descriptions and company standards. So again, it's super important that you have a policy, your handbook, that says, here's what our standards are, and we expect you to comply with these conducts. And also, here's your job description, right? So if someone says, you're not asking so-and-so to do this, you're asking me to carry these boxes in every day, not her. Well, here's your job description, and it says you're going to do that, right? It has nothing to do with your gender. It has to do with the fact that this is your job. That's why those are so helpful. So what are your responsibilities, really simply put, is of course to prevent harassment. And of course, again, that word reasonable, again, you have to have reasonable care to prevent harassment. So how do you do that? Is you make sure you have your policies and things we're going to talk about. And then you have reasonable care to promptly correct harassment. So you can't stick your head in the sand and say, I didn't know about it, right? If it's clear that you know or should have known that there's misconduct going on, you've got to take reasonable steps to promptly correct that. And again, you want to document that so you can show that you didn't ignore it, that you addressed the situation. Legal liability. Okay. So this is the part where it's scary, right? So we always talk about costs of doing business in New Jersey. And one of them is that as an employer, you have employees and there's a chance you can be liable if there's ever damages or concerns of harassment or discrimination. So the harasser may be liable for the legal harassment, the person themselves, right? That would be civil liability. So if someone says it's a violation of law against discrimination, and it's not just that simple, right? It'll be law against discrimination for wrongful termination, for failure to accommodate, for retaliation, right? Refusal to engage in the interactive process, aiding and abetting. All of those things are potential civil liability that an employee who's terminated or even just suffer some sort of adverse employment action can file a claim trying to hold you, the employer, liable. If there's any sort of physical conduct, of course, there can be criminal liability. But again, when you know or should have known, you have an obligation to take prompt remedial action, and that will all help protect you when any claim is made. Maybe not 100% to the extent we want it to, but it's the best way to protect yourselves, right? You want to make sure we document, when did you know about it? How did you know about it? What actions did you take, right? So that you address the situation. So the person who actually committed any sort of discrimination could be liable, again, for civil and criminal, and that's for discrimination. And let's talk about monetary damages, right? So in a typical case, right? So there is, you allege a breach of contract, right? You got your home improvements done, they weren't done. You file a claim against that person. Each of you pay your attorney's fees. There's a decision made as to who's responsible. And an employment case, they're very different when they're harassment and discrimination claims, because the law against discrimination provides for attorney's fees for a successful litigant. So what that means is, so say someone is alleging age discrimination. So they file a claim against you. Say they were discriminated against because of your age, you deny it. You've got one employee who made a comment at one point during the process, they're not a supervisor. You say that doesn't mean I am committing age discrimination. One employee said that. This person made $50,000 a year. So how do we decide? What is our potential for liability, right? So under the law against discrimination, it's not only the damages for the lost wages, it's back pay, it's front pay, it's any pain and suffering. And again, it's those attorney's fees and punitive damages if there's willful conduct. So that can become a huge pot. And what's more scary is, so say this was a $30,000 employee who would have been terminated anyway, who you're able to show as a poor performer. So the jury, you go through everything and the jury awards them $30,000 for 1 year. You are still responsible for their attorney's fees, right? It says employee fees, it means attorney's fees are paid. So if that person is awarded $1, you're responsible for their attorney's fees also. So that $1 becomes $101,000, right? Typically to get to trial, a plaintiff's employment attorney is going to say probably $100,000. So it's very expensive, which is why taking the time now, I get it, no one wants to spend the time on looking through your policies, right? They are what they are. It's worth the time and the money now to make sure you are suitably protected should a claim be made, right? Because they can become very expensive. I'm telling you, a person gets awarded $1. What if it's your high employee, your vice president, who made $300,000? When we go to mediation, what we typically do is take that salary, times it by 3, add money for pain and suffering, add monies for attorney's fees, and you're easily looking over $500,000, right? So it gets very expensive quickly. So you want to be careful and understand. That's why you want to make sure you're preventing harassment and discrimination. Of course, the other reason is you don't want harassment or discrimination within your workplace. But I totally recognize, I feel like I'm getting jaded today. There is preventing harassment and discrimination, and there's protecting yourself against harassment and discrimination, right? And they don't always go hand in hand, because we can't ever prohibit someone from suing you. All we can do is do our best within the organization to make sure it's not happening and to properly provide for a defense if a claim is made. Oftentimes we have employees who come and say, listen, I'm worried about what's going on. I don't want to rock the boat, but I just want you to know this is going on. What's so important is all of your supervisors within your organization understand that complaints can't be confidential. And if anyone thinks there's harassment or discrimination going on, they need to report it, right? Because we want the harassment to stop, right? That's the main reason. No one should be subject to harassment or discrimination in the workplace. I think we can all agree on that, right? We can't take action unless it's known, and we can't ignore it, because no good deed goes unpunished. If we ignore it and a year later that employee decides, well, I said I wanted to keep it confidential, but I didn't really mean that, right? Of course I wanted to stop. Then you're subject to greater liability and greater monetary expenses. So we want to make sure everyone understands, right? And we do that through the policies with how you complain. So when people are alleging workplace discrimination, how do they do it? You want to have a policy that makes it super clear, your complaint procedure, your complaint policy. Oftentimes when I'm drafting an employee handbook, I also include the complaint form, right? Here it is, simple, simple. If you're concerned about complaints, harassment, discrimination, please fill out this form, turn it in, understand to the extent possible, things will be kept confidential. We're never guaranteeing that. And understand that we're going to need your cooperation in the interview process, right? Whatever that interview investigation process might entail. It could involve one person being interviewed. It could involve a whole bunch of people. It could involve just a review of documents, but whatever's done, we document it and make sure that that's done confidentiality to the extent possible. Again, we can't require it, and we can't guarantee it, because oftentimes if there's litigation, that's something that will be shared later too. So again, that needs to be included in your handbook. Understand that an employee can come to you. They could also go in New Jersey to the DCR, New Jersey Division of Civil Rights. If you go onto NJDCR, just Google it one time, when you're sitting in front of the TV, it's very easy to file a complaint. And it'll explain to them what the protected categories are, how you file a complaint. Once an employee files a complaint with DCR, it gets assigned to an investigator, and then who knows what you're getting, right? You could get a person who is understanding, reasonable, looks at it and says there's probably not much to it, but of course you're still going to be advised. You're going to still have to respond and answer to that. You're probably going to be calling me or another attorney, right? And figuring out the best way to handle it. You could have someone who's super overzealous and wants to get to the bottom of it and interviews you, interviews a bunch of your employees, and then decides how they want to handle it. They can either issue a right to sue, or they can choose to take it on their own or do nothing, right? Then there's the EOC, same thing, but on a federal level. So, and there's certain claims that need to be filed with the EOC by a plaintiff ahead of time. But from our perspective, understand if you ever get notification from DC or EOC, you want to respond. You want to respond, I don't want to say aggressively, but truthfully, and to the extent that you're making it known that you didn't engage in harassment and discrimination. You're going to provide copies of your policies. You're going to provide training and everything you can to show that there's nothing wrong going on. All right, if it's assault, again, criminal charges can be sought. If you ever get notice of that, call the police right away so you document that and you have reports to show it. And again, certain groups of employees, if there's civil service or if there's a union, some of those things will be covered under the CBA as far as who complaints get made to. You want to make sure, again, that you have clear policies, address reasonable accommodations and harassment. So disability discrimination is a whole separate thing I can talk about hours for. But if someone ever makes a request for accommodation, or if you know they should have a need for a request for accommodation, you want to document that because you have an obligation to engage in an interactive process and consider what can be done as long as it doesn't constitute undue hardship, right? So it's a lot to that. We want to make sure that there's complaint procedures that are clear. We want to make sure that there's trainings. We want to make sure that there's monitorings, right? SurveyMonkey, all these things are super easy to monitor employees now. Throw those out once in a while. Prompt investigations, right? When I do investigation, my goal is prompt, thorough, and impartial. Want to make sure that's being done. And again, that can mean a lot of different things, but document what's being done so you can show that something was done. And we always want to be consistent, right? So we want to have uniform enforcement to the extent we can. I can say that all I want from this side, but I totally understand when you're investigating things, everything is always different, right? Everyone always has a different background. It's a question of how much people cooperate, but you want to be, to the extent possible, consistent, and particularly consistent in following your policies, and document everything, right? If you are going to have to defend your action moving forward, you want to be able to do so by showing that you've followed your policies, right? And here's your contemporaneous note showing what happened. So when we talk about your best defenses, what do? One thing is employment practices liability insurance, EBLI insurance, right? If you have employees, you should have this. The cost of it vary. They depend on what you're actually covering, what's your deductible, right? And that could be your deductible per claim. It could be your deductible per year, and what's your policy amount. I would argue that it's a huge amount, right? Because again, I'm telling you, if you have a $100,000 employee, if they make a claim, you're looking at a $500,000 potential liability easily, right? So I would think that would be the least amount of coverage you would want. There's people who are professionals in this area. You have your insurance adjusters, insurance agents who will tell you what the proper amounts are for your company based on your number of employees, based upon the type of business you're in. They're going to ask you a lot of questions when you submit an application for EPLI. I've been getting a lot of them lately because there's a lot of questions about what policies are in place, right? What you bring to an attorney. So you want to make sure, number one, that you have EPLI, because if you don't and you're sued, it's going to cost you a lot of money, right? Even if that claim comes in and it has no merit, just to answer your complaint, just to get through discovery, right, takes a lot of time and money. So you want to the extent possible, have EPLI coverage so that at least some of it is paid for. And again, depending on the amount of your deductible, it may be a long time before any of it's paid for, but at least if there is some sort of a large verdict at the end, that will be covered. And there's something called a hammer clause in many insurance policies. And just understand that it provides for the insurance company to at some point make a suggestion as to settlement, typically, of a claim for a certain amount of money. And if you don't agree to that, you're going to be responsible for additional costs, right? So EPLI policy, again, I think it's super important. And I think take the time, find out what your policy has, maybe do some shopping around. If you have questions, let me know. But I think it's necessary in today's business climate to make sure you protected yourself from at least those huge verdicts that have the potential to come in when there's claims made. So there's anti-harassment policies. They actually can serve as an affirmative defense if an employee unreasonably fails to comply with reporting harassment, right? So you've done everything right. It can be an affirmative defense if you have those policies, you have those trainings, and you show that the employee failed to do that. It's for harassment policies only, and it's only if the employee wasn't terminated. So it's only so helpful. But what you want to make sure to understand is the courts are going to look. Did you have formal policies? Easy if you have a handbook, right? Yeah, sure. We have a policy that prohibited harassment in the workplace. Do you have complaint structures, right? Formal and informal. Yeah, here's who you go to, and it's always an alternative, right? You don't have one person to complain to. It's not just your supervisor, it's HR, the company president, because you don't want it just going to the person who's the subject of the alleged harassment. You have to have trainings. You have to have trainings of all employees and then of supervisors. This can count, right? Whatever. If you're listening to me talking about harassment and discrimination, make sure you're having them annually and make sure you're also having separate trainings for supervisors to explain to them, scary world out there, need you to help us, need you to be on this ship saying no harassment, no discrimination. And if there's concerns, please let HR know so we can deal with it. Also, effective monitoring. What do you monitor? How do you monitor, right? They want to know what that is to the extent it's going on within your organization. And they want to actually see commitment that there's no harassment going on. How do you show that? Is if there's a substantiation of harassment, did you deal with it? Did you engage in appropriate disciplinary action? What did you do? And then your commitment to the policy again through consistent practice, right? If there's concerns, here's what we did. So that's what courts are going to look at to see if you can have an affirmative defense if there are harassment claims and the employee didn't take advantage of your policies, right? You had all these, you train, you have handbook, you have policies, and this employee sues you, but they never told you about the problem. How could you fix a problem if you didn't know about it is the purpose of this defense. Again, only for harassment claims, but if you have reasonable care, if you have those policies, it's going to help you. So there's one reason it's worth it in addition to all the other reasons we just said. Again, if there's an intangible employment action, a termination, it doesn't apply, which is a bummer. Also, if you had an ineffective policy, meaning the employee can show other people complained and nothing happened, or if it's failed to be enforced, like, there's harassment rampant in your workplace, then it's not going to be effective. So revisit your anti-harassment policies, make sure that you show that you have a commitment to prohibiting and preventing illegal harassment. There's a reporting mechanism, your complaint procedure, again, at least 2 people, so there's at least an alternative if the one person is the person complained of. Make sure you have training, really annual training, and you want to make sure the employee always acknowledges your handbooks and the training to the extent you have people sign in. That's all you need to do, at least have them sign in so you can show that that's being done. So when we talk about the policies themselves, that's the most important part, right? It's a real baseline thing to do to show we really do believe in anti-harassment, anti-discrimination, so much so that we either, sometimes I have employees who use ADP, right? They have that handbook in place. Or if you're a business trade and you have an organization that creates handbooks, that's fine. Or people like to go AI, right, and use policies. I draft policies. Of course, I think mine are better. They all have to be tailored specifically to you. There is no one size fits all. Everyone has different vacation days. Everyone deals with sick leave differently. Everyone doesn't want to have the same sort of progressive discipline or not, right? Everything should be tailored. It's fine to start with all those different drafts, but I would suggest you eventually have an attorney look at them once you have it put together, because there are certain things that need to be in there and should be in there. And they should be reviewed annually, right? Because there are changes in the law, there's updates, things that happen, so they should be reviewed annually. What should be in your policies? Define that harassment, just like we did earlier today. I'll give examples. You want to cover protected characteristics, not just the big 5, but make sure you're saying and anything else protected by law, right? Because that is going to change year to year. I want you to look at these year to year. They should be living documents, but always, cover yourself to the extent possible. And it applies to all employees, managers, contractors, vendors, perhaps volunteers if you have volunteers, right? We want to make sure those policies apply to everyone, and prohibit retaliation. Retaliation is one of the areas that the government agencies have been looking at enforcing. We don't want someone to allege harassment or discrimination and then be retaliated against, lose a position, terminations. We want to make sure you're clear on that policy that you don't have retaliation. And again, those multiple reporting channels. So in case there's a conflict with one person, you can go to a second. Again, all employees, every report will be investigated, not always the same, but to some extent will be investigated. You provide that choice of officials, who do you complain to, and ensure that violations will result in disciplinary action. One important thing is if you are doing an investigation, you want to make sure that expectation is clear from the beginning. That person who makes a complaint will only be informed, in my opinion, whether the allegation was substantiated or not, and whether appropriate disciplinary action was taken or not. That's all they're going to know, because you've spoken to individuals, you've promised them confidentiality to the extent possible. So you want to be sure that at the end, we're going to get back to you and say that we finished this, we did what we said we're going to do, and if it was substantiated, yes, and we took discipline. They're not going to know what the discipline was, right? But we want to get back to them, but we're going to be very general. We want to set that expectation early so it's understood by everybody. And also there should be zero tolerance for retaliation. So understand that if someone makes a good faith complaint, we're going to make sure they won't retaliate against. If someone makes a bad faith complaint and we can show that, Similarly, we can discipline them. Again, there's going to be examples within that policy, and we're going to state it's unlawful conduct. We don't want any discrimination in the workplace. We're going to say that we have a commitment to maintaining a non-discriminatory working environment. We're going to eradicate sexual harassment. Sexual harassment, we oftentimes even have a separate sign-off because that really is the most rampant and common, sexual harassment itself. So sometimes we put that separate and give other examples specifically as to sexual harassment. Again, we want to let people know their complaint is confidential to the extent possible, but people are going to know about it. We're going to investigate it. But to the extent we can, we'll keep it confidential. You can describe the complaint procedure within your policy very generally, but explain, prompt, thorough, impartial. And again, what are the remedies? What's going to happen? You're just going to be advised generally, but there's no tolerance for harassment or discrimination and no tolerance for retaliation. So when we train, that's a second step, right? First is the policy, second is the training. So we tell people what it is, right? Because we all have that one employee who says, my boss is so mean to me. They get really upset when I come in at 8:05 every day. That has nothing to do with any protected class. It's because you're supposed to be there at 8 o'clock every day, right? So explain to that employee when they come to you, listen, that's not harassment or discrimination. That's you being asked to do your job, right? And that's where the training comes in, right? You explain to everyone, and I'm like on the bad side of the coin today, telling you how easy it is. But we also want to make sure employees know we're going to hold them accountable to perform their jobs. We're also going to protect ourselves from harassment and discrimination claims. So we're going to explain to them what harassment and discrimination is. We're going to instruct how to eradicate harassment and discrimination. So again, if you have concerns, you need to tell us, right? And we're not going to ignore it, and we can't ignore it if you make a complaint. Conduct that might be interpreted as harassment and discrimination. So just like we're talking about examples, when you have your training, you want to make sure it's clear what's harassment and discrimination versus what's being asked to do your job. Bystander intervention, like what do we want? If someone sees harassment or discrimination, we want them to tell their supervisor, tell HR, tell whoever it is within your organization who's identified as the person to do that. And also we're going to make clear in our trainings that there's no retaliation, right? So that's the worst part when I go into some organizations to do these trainings, right? So I'll do the handbook, we introduce the handbook, we roll it out, and I give an introductory training. Not very long, usually about an hour. Sometimes if it's a big employer, it's in shifts, right? And I've had one last year where I think it was 4 or 5 shifts. One shift of the 30 employees or so, nobody says a word during the training. Second one, they're catcalling on their way in, they're talking, they're giving me examples, right? Different. Third one, again, was quiet. And then the fourth one, you can tell, like there was one employee who was the problem and they were the one there. So even that is an opportunity to say, oh, there's clearly something going on here, right? I understand there's a concern. They're using inappropriate language. People aren't looking at them, giving examples, right? So as training is sometimes a great time to look at the employees, explain to them what's permitted and not permitted, and whatever you're prohibiting, don't allow it to go on during the training, right? That needs to be shown as an example of not okay, right? And what are we going to do about it? So you want to make sure that training is clear. Again, all employees together, and then a separate one for supervisors as best practices. Routine part of orientation for new managers. So again, those people who are charged with implementing your policies need to be well aware of what your policies of harassment and discrimination are. And then again, you can have your own trainers, there's consultants, there's law firms, everyone who can do the training. There's online training, of course, there's question and answer training, there's all different ways to do it. There's quizzes, videos, different computer-based programs. So whatever it is, just make sure you're doing the training, make sure you document who attends. And I can't tell you, we had one case one time where they told me everyone did the training. Guess who didn't do the training? The company president. Guess who was just complained of for harassment and discrimination? The company president. Please, everybody, no one's above this, right? Everyone should attend the harassment and discrimination training, particularly the supervisors and the higher ups. It's important, and you show that from the top down. So monitoring your harassment and discrimination, again, you can survey your employees, particularly if someone has filed a complaint, you want to follow up with them and say, like, do you feel like things are okay? You don't feel like you're retaliated against anyway, like confirm that things are okay. And also like any suggestions for anything in the workplace, follow up with everybody to make sure you have a system that monitors your policies and practices. And again, you're going to do this too when you review your handbook each year and you have your training. So note, your EPLI policy may require more. So lately, some employers have been sending me their EPLI policy questionnaires, right? Because it's confusing. They are in these policies wanting to know, do you do annual evaluations of your employees? And oftentimes in our handbook, we have evaluations may be conducted, right? They want you to confirm that you will conduct evaluations annually. And I know in some small organizations, that's really hard. And that's where we talk about having self-evaluations is usually a great first step, right? People will have their self-evaluation, meet with their manager, and at least have some sort of annual evaluation because they are important, because they show you how an employee is performing, if they're effective, right? We want to make sure managers aren't giving every employee 10, 10, 10, 10, 10. And then you call me and say they're a terrible performer. That's why we terminated them. And they also want to look at your policies now. When you're applying for your EPLI insurance, oftentimes the question is, do you have a handbook? Does your handbook prohibit harassment? Does your handbook prohibit discrimination, right? They want to see your actual policies, and they want to know the last time an attorney reviewed it. They want to know who complaints go to, right? So all of these things that help us prevent harassment and discrimination are actually going to be part of your EPLI policy. And if you don't have them, of course, well, I shouldn't say of course, I don't know this, but I'm assuming the cost of your policy may go up or down depending. And I know with some clients too, we've assessed the issue of, okay, so we had a claim, how does that affect it? They're going to tell you they don't know because it changes year to year. But make sure you're comfortable with the amount of deductible, make sure you're comfortable with the amount of coverage, and use that checklist of what's required to help you. Because again, just like job descriptions are important, that might be part of the requirements, just like evaluations are important. Those are things that you should be having regardless if you have EPLI or not, though I would think it would be helpful and you should have it. So technology and the impact of technology on harassment and discrimination. So technology's changed everything, right? We can say that clearly. And I first was like, I'm not going to use AI. And then I realized when I'm Googling, I'm using AI, right? Like it's everywhere. You can't avoid it. And there is a huge learning curve, right? So I did a presentation with the Sussex County Chamber with some individuals who are cutting edge tech, and I am not that. I perfectly admit I can barely use my phone unless my kids help me. The things that you need to know to effectively use AI and protect yourself are a big deal, right? Particularly if you're in an industry that has to worry about confidentiality, make sure you understand what AI is about and how you protect yourself and whether you should have a paid subscription so your stuff isn't out there for everybody, because it is going to change. I think it's almost like how the internet changed things, right? So social media we still have out there, but that's still getting crazy too, right? Because of AI and how they can change things and how pictures come in. I just spoke about how we used to not care what happened on the weekends. Now, not only is a camera out all the time, now people can make stuff up all the time, right? They can make videos that seem very real. And if that's happening on the weekend and some of your employees find out about it, that's going to lead to problems in the workplace. So that's why we want to understand what's going on and making sure there's no harassment or discrimination in the workplace, because it really is going to shape how things are affected, within the workplace. And of course, we can talk about how AI helps with contracts, right? Can help you start with an employee handbook. I would still argue, and I think most people would agree, you still need to have counsel review those at the end, because AI isn't always true. It's not always right? And that's what we need to train employees on too. It's a good start. It often helps you get a good start on things, but it's not always accurate. It's not always end all. And particularly, I've started to play with it and look at things. It gives you wrong answers. It just does, because it's not 100% reliable. So you want to make sure, particularly for legal research, it gives the wrong answers on like leaves and things like that. So you want to make sure you don't rely on it for that. Use it to the extent it can help you. And let's train our workforce so we understand what AI is, how we can use it to help us, how we're not going to be harassing or discriminating on any sort of technology facet or app or anything like that. Okay. So why does technology, social media, AI have a negative impact? It's misinformation at times, right? Something gets out there and people think it's true. Doesn't have to be, but people think it is. Huge concern is privacy concerns and data tracking. Again, I do not pretend to be the expert, but right, so it used to be ChatGPT was the leading edge, and now there's Google Chrome, and now there's a new one that popped up on something the other day that I don't even know what it is, right? If you're using different AIs, they're subject to different tracking, different rules. So you want to make sure you have your employees, your workforce understands, like, what are we going to use, right? Are you okay with your employees putting in all of your company information so it's out there? Probably not, right? Which means then you therefore want to have a paid subscription to one of the places. Do you pick Google Chrome? Do you pick ChatGPT? I don't pretend to know which one is best. And as I understand it, it changes week to week, right? Because someone will get new technology, some will have new advancements, or it might depend on what industry you're in. Or do you want something that's going to write letters versus presentations, right? There's all sorts of different platforms for that. But to the extent that you choose one you want to have, you want to make sure that your privacy concerns are addressed by having a paid subscription that only your employees can have. So that data isn't tracked to people outside of your organization. So mental health effects, if any of you have children, you know about that, right? When children, I'm talking about my own here, who you think would make good decisions, don't necessarily do, right? When it comes to social media, it's too easy. It's right there, the hand. I'm glad I'm not growing up on this age for what its effect for that, but just understand that people are on it too much, right? And it messes with your sense of reality, I think. And there's addiction. And then deep fakes, that's a huge problem, right? And AI manipulation, we get emails all the time about someone looking for our business. Are they real? We get videos, again, that you think are real, but they're not. So you want to make sure we understand how that technology affects us as an employer. Number one, how do we allow it into our organization, if at all? Number two, how do we use it? You know, if it helps us write letters or if it helps us get things done more efficiently, let's use it. But let's do it the right way, where we are protecting privacy concerns, and make sure that all of your handbook rules, policies, and procedures, not just harassment and discrimination, but confidentiality, right? All of that applies to that use of social media and AI. So again, technology is altering our landscape of harassment and discrimination because, you know, the question was, what can we do with social media when people first started coming out? Now it's going to be, what can we do with AI? How do we address how our employees utilize AI? So there's more severe forms of abuse now, right? People can almost anonymously, as I understand it, right, provide negative reviews, negative comments. So you want to be careful of that and make sure if someone has a concern about it, they let you know so you can address it, right? Maybe it's blocking things, I'm not sure. But there's also at the same time new tools for accountability, right? And prevention. There's things you can do to block that weren't there before. There is a way to account how effective and efficient your employees are. So if you use those, you want to, first of all, decide if you're going to let employees know, which I think you should. You know, we talk about video cameras, which you generally, but again, should. New Jersey is a one-party consent state, meaning only one party needs to consent to record a conversation. So you want to make sure all of these things are in the background while you're performing what your job is, right? So it's a lot going on, and I get it. But again, understand that AI is making harassment faster. It can be more anonymous. It can be more invasive. And there might be trails, there may not be. I'm thinking of the Samantha Guthrie case, right? Like, holy cow, how have they not found this person when they put this Bitcoin thing out there that I'd assume was trackable? And again, that's where I get lost. That's the limit of my knowledge. But it shows you, right? Like, this is a huge developing area, and we need to understand what our employees are doing, because ultimately you're responsible for what they're doing in the workplace. And we want to make sure they're using AI in a safe and effective way, and that our employees are safe from harassment and discrimination. So when we talk about social media policies, we've had these for a long time, right? Gosh, I'm thinking it was probably 15 years ago, maybe more. A social media policy came out from the state, like telling us what we could tell our employees to do, right? Because it was like, we don't want to infringe on their rights, but can we use it in the workplace? I'm going to date myself entirely. There were days where we said no cell phones at all, right? It was a reasonable policy to say people couldn't have their cell phones out. Can you imagine now if you told people they couldn't look at their cell phones the entire day? They'd die. So things are changing. This is an area where it's going to be a living document. Your social media policy is one of them. You want to clarify what can be used and when. Are you okay with people checking at lunchtime? Are you okay with people checking at breaks? We have to allow people to use internet because they use it as part of their job, right? The things you can find out there that are helpful, not only for, you know, content, comparison, samples, right? Things like that. So people are going to use the internet part of their work. How do we make sure they're doing it in a safe way? Personal and business use. You can absolutely prohibit personal use of social media at the workplace, and you probably want to. As I say that, I know several of my clients who have employees whose almost sole job is to make sure they're on social media, right? So is it as the company? Is it at themselves? Are they, you know, giving thumbs up? Are they putting your company out there, responding to other stories? Are you blogging? There's so many things to consider, and you want to make sure you allow personal use or not, business use or not. But again, be very clear in your policies. Harassment and discrimination policies apply. So if anyone's harassing, if anyone's discriminating against anyone in their post, not okay. New Jersey, there's a legislation that came out a couple of years ago now. You can't say to your employee, I need access to your social media accounts. So you as the employer can't do that. That doesn't mean that your supervisor isn't on, well, Facebook's so old now, right? Isn't on Instagram or Snapchat with somebody, because which is the one that has stories? I don't even know, right? But your supervisors, if they're on social media with their employees, are probably finding out about those employees' personal affairs and conduct. I don't know if that's a good idea or not. Probably not. And how does that affect how they interact with them in the workplace after they see what they're posting on their Instagram account, right? You can't find someone and ask them, give me your access to Facebook. But if someone's been out for 2 weeks and they say it's because they've been sick, but their supervisor has seen them pictures in Mexico on a vacation, right? That's a problem you're going to have to address. So you can use social media that way, but you can't demand personal social media account login information. Employees can face discipline for public discriminatory posts that violate company policy, right? If someone's going out there and you want to have a policy that says this, right? And they're embarrassing you and they're using the name of the company, huge issue, right? If they're doing it by themselves, is it harassment and discriminatory, right? Is it in bad taste versus is it against policy? Huge gray area. Politics, we never discuss religion and politics, right? If people are out there putting out all sorts of information about politics, it's very divisive right now, right? So you want to make sure you have a policy that addresses how you're going to deal with that. Probably not very much, unless it comes into the workplace, right? If it comes into the workplace and affects how people are, and people are using their social media, and they're now communicating with clients, right? That's where it becomes more of a problem for you to deal with. So when you talk about your AI policy, when can it be used? What can it be used for? And let your employees know about these risks. I don't know that everybody knows about it, right? We don't know who owns the AI content even, right? Like you talk about trademark perspectives, and there are really serious security and privacy concerns. If you have any confidential information, you don't want your information out there in AI right now. And let your employees know it can be inaccurate, it can be outdated, it can be misleading, it can just be outright false, right? We need to train our employees so they understand that's what exists. So what does your policy say? And I've been drafting some of these, and I've got to tell you, I'm changing them still every time because things will happen, circumstances happen, someone calls me with a question, right? And I keep changing my AI policies. It's the perfect example of a living document, right? I'll tell you exactly what I think should be in there generally, but something will happen. You'll have a specific instance that changes what we think we should allow, what we shouldn't allow, what should be in our policy. And again, remember, when you have an employee handbook, one of the things we put in the beginning is that it can be changed at any time without notice, right? We want to give notice, we want to send it out, but if you see something and you're like, oh my gosh, I need to do this and I need to do this now, change your policy. And then my suggestion would be at least get a copy of that page with an acknowledgement for that page so everyone understands there's a change in what we're doing, but you can change it at any time. You don't even have to give notice, but I suggest you do. So number one, are you allowing AI, right? Do you allow AI use? And are you allowing business emails to create accounts? So my understanding, again, from when I've done this, is if you do a chat GPT, you have to set up your own account, and that's what you dump your documents into, and that's where everything gets stored, and that's where you want to have a paid account for your organization, likely, unless you don't care, you let people do that, but what's their email? Does it have to be their personal email? Can it be your business email? Of course, that's going to raise concerns for you if you're using business, which is why you want to direct people where to go, right? You want to tell them, if you are using AI, we suggest you use this, or we require you only use our paid platform, blah, blah, blah. And that might change, right? Because I was just telling you, as I understand it, technology changes. So in 6 months from now, that might not be the good platform. You might want to use another one. Fine, but make sure you're clear in directing employees what to do. And put that in writing so that if an employee goes out there and puts all your confidential information, you can discipline them for that because you had a policy that said don't do that, right? Make it super clear. Do you allow personal use of AI accounts, again, at work and in the workplace? There might be a reason for that. There might not be. Depends what your business is and what you're looking for. If it's in marketing, that's very different than if you're a confidential paralegal, right? And then searching AI too. So it's not just the use of creating accounts, but searching things. I can't think of an exception that no proprietary or confidential information may be entered into AI, right? That's the rule. Unless, again, you have a paid platform that you as the employer have decided is safe and secure for you, but the general rule should be no confidential information. We don't want that out there. So another thing you may need to make clear to your employees is that all AI-generated content must be reviewed for accuracy before you can rely on it, right? So people are getting lazy now because you can just type blah, 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 and it's done for them. No, you need to go back and look at it just like you would. There's a reason we have you as a human here and tell people like, okay, if AI is going to help you, like we encourage that for efficiency and effectiveness in the workplace, but it's your responsibility still that it's accurate. Like I've received things that you know that they're AI, right? You can tell by the language, you can tell by the lack of personality in some of them, right? That they're AI. And you talk about, I'm glad I'm not a teacher right now. That'd be crazy trying to figure this out. But there's ways to track, as I understand it, like when people look at papers, right, that you can find out what changes were made, how they were made to show whether it's AI. I'm not suggesting you do that as an employer, but make sure your employees know, like, still look at them. AI is good, but it's not great because, as we just said, it could be false, it could be wrong. So make sure you're looking at your work and make sure they understand that. Because when we're evaluating employees, if they send out letters to the wrong addresses, if it's the wrong information, we're going to discipline them just like we did if they were doing that 10 years ago, right? We want to make sure people are performing at the same level. And again, if you can't rely on a source, if you can't verify the factual accuracy of it, we're going to tell them not to use it. I think of when we went from our big encyclopedias to just using the internet, right? So now it's the same thing with AI. You can't always trust it. What is it? Wikipedia isn't always right. AI isn't always right. So tell people, like, if you can't get the answer on AI, you're going to have to go back and do it the old school way. And if you can't verify the answer on AI, it might be a good start again. It might tell you where to start your research, but don't rely on it until you can verify it. So again, anyone who violates any of your AI policy is subject to disciplinary action up to and including termination. And you want to apply this consistently and uniformly, right? Just like every other policy. And AI use must be in accordance with all of your other company policies, meaning no discrimination, no harassment, and you need to maintain confidentiality. So New Jersey is a little special. So when Trump came into office, he said, listen, we're going to allow AI. We're going to go big on this. He issued some guidance, and New Jersey in January said, you know what, we're going to issue our own guidance. And then what we're going to say is that we're not going to allow discrimination from AI, right? So what it says specifically is New Jersey LAD, so we talk about that law against discrimination, prohibits AI discrimination, right? So what this means is just, again, make sure we're monitoring it make sure we understand that AI can't be utilized for harassment and discrimination. And it went further and said, New Jersey Attorney General's office said, there's 3 areas basically where your AI or your decision-making tools can lead to discriminatory outcomes. Number 1 is designing that tool, right? How do you use it? Number 2 is training the tool, again, beyond my pay grade, but there's input you put in there, right? So say you're looking to hire an employee to fill a customer service position, right? You train that AI tool to, do you want them to type certain speed per minute? What you don't want to put in there is an age, right? If you're doing a video interview, are there certain things you're looking and training it for, right? That's training the AI tool. And then deploying the AI tool. How are you actually utilizing it? Those are the 3 ways that the New Jersey broke it down into, like, these are the problems. This is where you can have discriminatory conduct. So again, when you're thinking about your use of AI, look at this and understand that's what the state is going to look for. Did you design it fairly? Is it training fairly? And is it deployed fairly? So when we look about designing the AI tool, what the New Jersey guidance said is we have examples of things that have been done wrong in designing the AI tool. So there was a company that programmed a screening tool to reject female applicants 55 or older and male 60 or older, right? Because when they're putting in what they want for their ideal candidate, age discrimination, gender, right? Like, you can literally, like, someone wasn't thinking and just said, well, this is what I want. You can't do that, right? You've got to at least not discriminate against in choosing someone based upon their age or based upon their gender. So what the company ultimately did as part of this case with the EOC is said, we're going to settle the case. And part of that is we're going to stop getting inputs like date of birth. So, back in the days when we did actually handwritten resumes, what we would say is we don't want to know the year you graduated college because then we know how old you are, right? Same thing. When you're designing your AI tools now, it's the same concept. It's just on a broader scale and a more electronic scale. Now, what about training the tool? How can the training be harassing or discriminatory? Discriminatory. So an example is a video interview, right? So how can that be wrong? So when you look at certain facial tones, when you look at expressions, when you look at what people are wearing, there's certain things that are attributed to some organizations more than another, right? So if there's one that looked for a facial expression or sex or race that's outside of what's normal, that could be a problem, right? So it's if someone has a certain language, right? If they use a certain accent or if they use certain phrases, there's certain tools that can be seen to have said that, okay, so that's not proper. And then that's discriminating against someone based upon that sex or race. So if someone speaks, I'd be out, right? If you spoke too quickly, we don't want that. It's just because I speak too quickly. It's nothing to do with anything else. If you're discriminating against me because I'm from New Jersey, nothing I can do about that. But if it's because I'm of a certain race, religion, right, or any of those protected categories, now we're talking something else, right? If it's because I speak in a deep voice, or if it's because of something related to my age, that's going to be the problem. Or if I have too many wrinkles, right? They look at that somehow, and who knows what the AI tool has. But again, what you're looking for is making sure your design, your train, and your deployment isn't in violation of this New Jersey guidance from the Attorney General. So now we talk about what are your AI tips. So again, understand what you're using. What's your tool? Again, what's your platform? What's the design development process? Because if you're using whatever program, you're responsible for what it's doing, right? So understand that, and that's the second thing here. What are the potential risks? What are the liabilities? So you understand what it is that you're allowing. Properly train your employees. I can't stress this enough. Don't assume that people get it, right? Ensure they're using AI properly, have a policy, roll it all out there so everyone's on the same page. And audit your tools, right? Don't just say, here's what we're doing, and then leave it alone for the next even year, right? These things are changing like crazy. Make sure that it's being used appropriately and audit it. Take a look at it. Make sure everything's happening the way you want it to. So technology is expanding both our opportunity as employers and our risk as employers. Hopefully I explained that okay. So you understand, like, you as the employer have that obligation for no harassment or discrimination within your workplace, and that includes AI, right? Make sure that your AI isn't further perpetuating any sort of inappropriate or illegal conduct. Social media is going to shape our company reputation, right? So I get it. You want to be on the rush. You want to be forefront of, like, let's use AI. Let's figure this out. But again, understand and make sure people are trained and understand the risks of that. Clear guidelines. Have a policy, right? Have a policy as to here's how we're going to use AI. Here's how we need you to protect confidentiality, no harassment, no discrimination. And again, responsible behavior protects everyone, and get everyone on the same page now, right? Let's get out in front of it. So make sure everyone is able to do that. So we prohibit harassment and discrimination moving forward. That is all for today. We will be sending out further information. Our next seminar is going to be a live one again, my favorite, for a couple of hours instead of these shorties. If anyone has questions, suggestions, anything like that, please reach out. I appreciate your time and have a good rest of the afternoon. Thank you.